So really, how do we now define the duty of care? What can we say about it? Where do we find that duty of care? If we're looking in the common law, we're not possibly able to look at the regulatory regime and what the regulatory regime sets up. So cases like Smith and the National Farmers Union and Chadwick and Ovenden look a little bit at what that duty of care might look like now post the Enterprise and Regulatory Act. I do want to say a little bit about contributory negligence, because I think it's always a challenging idea in accidents in the workplace. And I think I would argue that it's slightly different than the way it works in RTA. And I think it's worth just looking at, of course, we can never be prescriptive about it, court's discretion, etc. But I think we can see some themes emerging, and I want to say a little bit about those. Ever present and always going to be relevant is the area of risk assessment, and quite what that means in terms of employers' duties and how the court looks at what a sort of reasonable risk assessment might be and might look like. So Shell and Tarmac is a case I want to look at, the 2022 case, Court of Appeal, and the Goodwillie and B&Q case is also instructive, I think, in that regard. Just coming to the end, just want to mention the Hill and Ministry of Justice case, where the recorder was entitled to dismiss the prison officer's claim against the MOJ, where he was injured by a young offender prisoner. The duty to take reasonable care required the baseline risk to be addressed within a safe system of work, and the recorder was entitled to find there was no risk above the baseline risk already posed by young offenders. The appellant suffered a spine injury when working in a probationary as a probationary prison officer. He was instructed to escort two young offenders from segregation back to their cells on his own. When they reached the first cell, one of the prisoners pushed the appellant so the prisoners could barricade themselves into the cell. And during that assault, the appellant sustained serious injury. The figures were that the inmate was a volatile young man and fell within the worst 25% of prisoners in terms of conduct. But the court didn't accept that he was very dangerous as a prisoner, and it wouldn't have been necessary to see him as high risk. They also found that he didn't pose any imminent or foreseeable risk to staff beyond that routinely faced by prison officers. So we need to look at the background risk of a routine risk.